Okay, that's one, right? So that's one, right, just key point of the law, that it has to be utterly clear and accepted that a Beit Din has the right to give permission to go to secular court whenever, in its belief, the alternative will not yield justice, and it has to be taken as a given that an unsupervised zavla is a recipe for corruption and will not yield justice. And many great poskim have said to me, Saravocha, that Rabbi Bechover, before Rabbi Bechover said this to me, that in a circumstance where the choices are a secular court or an unregulated zabla, that probably halachically it is preferable to go to secular court because going to zabla is going to be theft. So all the Beit Din that are established try to use some method of regulating this, but they have difficulty doing it according to the law. So if you take a look at page 9 again, so you'll see that this is Rabbi Yonah Reis, who was the Menahel of the Beit Din of America, which really is the gold standard. Particularly when he ran it, it was the gold standard in terms of rabbinic courts in America, in terms of professionalism and consistency and all those sorts of things. So he said, we also discourage the use, right, so first of all, they don't allow rabbinic advocates to participate. I don't know how they pull it off, but they apparently do. So we also discourage the use of zabla, except in limited cases whereby parties choose their borim, they choose their justices from a roster of dayanim who are members of the Beit Din and have been found to be trustworthy and scrupulous individuals. And otherwise, if you don't agree to choose from that roster, then they write you permission to go to secular court. Now, the Beit Din of Detroit also says, right, the Beit Din of Detroit requires that both sides pick judges who regularly serve on the Beit Din or who are recommended by the Beit Din. And what I mean by regularly serve on the Beit Din is not regularly serves on zablas, but regularly serves on a Beit Din that we recognize as trustworthy and honest. So every Beit Din that has any sense of responsibility tries to regulate any zavla that the client goes to. If you don't allow a zavla, then you're stuck because it's very, very rare that two litigants agree to the same Beit Din in New York. Everyone has their own sub-community. So you have to end up with that. So there's only one other, right? So that's one bottleneck. Really, what we're saying is that there are, the first bottleneck is whether you can enforce your judgment. The solution to that is an arbitration agreement. But the arbitration agreement has to be written very, very carefully to make sure that both parties are bound to a system that can yield justice. The second bottleneck is a claim that is to freeze it on the choice of whether to go to zavla or not by refusing to agree to a regulated zavla. The solution to that is to rule that refusing to allow your zavla to be regulated by the Beit Din, even though you won't go to the Beit Din, but refusing to allow your zavla to be regulated by a Beit Din is tantamount to refusing to go to Jewish court. There is a third thing, which is that the right to go to zavla, this we mentioned in Tosfot, the right to go to zavla only applies if there is not an established Beit Din in the city. Right? Meaning if there is no court that can reasonably be understood as having compulsory jurisdiction over both of you. If there is a court that can reasonably be understood as having jurisdiction over both of you, then you don't have the right to go to zavla anymore. So the question is, are there any circumstances that we would view nowadays as having compulsory jurisdiction? So if you take a look at page 7, I would bet. I just have to find it again. Yes, page 7. So on page 7, you have a response to Rav Moshe Feinstein, which he writes, and when Rav Moshe Isserlis wrote, or the Ramah writes, that if there are established judges in the city, a litigant may not say they will not go to judgment before them, but rather before a zavla, that applies only to the cities of Europe, where they would be appointed by the city, and in those cities, even the rabbi who headed the local rabbinic court could compel judgment before him, even when he judged alone, since they'd accept his authority upon themselves. But in New York, there are no established judges who have been appointed by the city, especially as there are other groups and fraternities of rabbis, meaning that there isn't even an appointment by all the rabbis of the city, and therefore if either litigant wishes a zabla court, they are compelled to go to a zabla court specifically. Okay, so Rabbi Feinstein ruled unequivocally that there is no such thing as a fixed court nowadays in New York City. And so in New York, you cannot claim compulsory jurisdiction, and the only way to evade zabla Right? The only way is to say that we'll write a permission to go to secular court unless you agree to our rules. So you go to Zavla, but under the same rules. Rosh Shlomo Wolbe, Shevet HaLevi, who's on page 8, says, Your Honor asked me to he's writing to his son in Montreal. Your Honor asked me to specify in writing the basis for my opinion that if the defendant wants to go to judgment before a court of 3 scholars who are acceptable to the populace, whereas the plaintiff wants only a Zabla court, that in my humble opinion, the law is with the defendant. Okay, because where there is an established court, one should not go to judgment via Zabla. So he says there's no time to write extensively. My reason is simple. Number one, in my humble opinion, there are in this day as well established courts, as against various authors who completely eliminate the category of established court. So he says, I just think it's false. He disagrees with Rabbi Feinstein entirely, and he says there are established courts nowadays. And then he tells you, number 2, regarding Zabla, did not Rush and Tur already write that a Zabla judge may not exaggerate or lie, and they write that there are some mindless people who think the judge chosen for a Zabla court should search for merit in the case of the one who chose him, and he stands in his place to upset things so that they go in contrast to the law, and as a result, a significant number of people adopted the practice of choosing a trickster judge. Okay, so Rabbi Wolbe in the end says that he doesn't understand how anybody could think that sending people to unregulated Zabla is a reasonable thing. If you look on page 9 at the end, he says, according to this, it would be acceptable if both agreed to this, but if one side is on no account willing to agree to this twisted method, meaning one side wants a rush court and not a Shulchan court, it's obvious that he cannot be compelled in this matter, period. Okay, so Rabbi Wolbe takes 2 positions. A, he says there are established courts, and B, he says that even if there were not established courts, it's ridiculous. You can't claim that somebody should be compelled to go to a court which is a kangaroo court. Now, some people have argued that Rav Moshe, when he said there's no established court, he didn't really say there are no established courts nowadays. He said there were established courts in Europe, there are no established courts in New York. What about Boston? Or Detroit? So a reasonable position can be said that in Boston right now, there is only one Beit Din. So whether or not that Beit Din has the universal approval of the rabbinate and the populace, there is only one Beit Din. There has been only one Beit Din for a long time. So one could take the position that that the Beit Din of Boston is a Beit Din kavua by the Ramah's terms, and when there is a Beit Din kavua, you simply can't demand Zabla. That would be that I suppose would be the best case scenario. At the very least, it seems to me that one should be able to construct a reasonable. One should be able to construct a reasonable argument that at the least that the Beit Din is a Beit Din kavua to the purposes that if you want to go to Zavla and you want to be able to prevent the other party from going to secular court, you have to accept the rules that our Beit Din sets up for Zavla, which will be that you have to follow the rules of the Rosh as opposed to the Aryeh HaShulchan, and that we monitor it to make sure that none of the Borim are using Aryeh HaShulchan tactics, alleged Aryeh HaShulchan tactics. Again, the Aryeh HaShulchan himself, I don't think meant it that strongly, but that's what it plays out in practice. So if you look at the last page on page 10, right? So this is a form that had to be made perhaps to make standard in the Boston Rabbinical Court. Right? So it says, pursuant to legal claim followed by X against Y in the Boston Rabbinical Court, X has requested that the dispute be heard by a Zabla. Right? Please understand the procedure of Zabla does not mean that each side chooses an attorney, or that each side chooses a judge, right, whose purpose is to argue on behalf. Rather, all judges on the arbitration panel must perform their duties impartially and must seek to reach a just verdict in accordance with Jewish law and values. Zabla is intended to assure both litigants that their cases will be fairly and completely heard, so that they will accept the verdict happily as enabling them to fulfill their Torah obligations. It does not establish an adversarial system in which competing interests battle it out, but rather a cooperative system in which each side contributes to the joint enterprise of discovering their respective Torah duties and rights. The Zabla format can lead to unfortunate delays if it is not carefully managed, and justice delayed can be justice denied. The Boston Rabbinical Court will assist in the development of the Zabla court only so long as both parties demonstrate their commitment to moving forward expeditiously and in the letter and spirit of Jewish law. So that's right. So really, in practice, what happens 99% of the time right now is that we don't have the social power to compel the other party to come. So we end up writing a heter arkaot, but I think that we have reached a comfort level, which I think is correct, that that the nesivos is misunderstood, and that therefore, if the other party demands unregulated zavla, we have the right to give permission to go to secular court. My hope is that if the parameters of what I'm setting out tonight become clear to everybody, that over time, it will be possible to have either cases in rabbinical court or cases via zavla that are properly regulated, that makes rabbinic courts and halachic courts at least as viable an alternative as any other form of ADR, of any alternate dispute resolution. Right now, everyone understands that the American court system yields massive, massive costs, especially in small cases that make it really unworthwhile, and that there are deep inequities in cases where one side can afford a lawyer and the other side can't. And so parties interested in justice often will resort to arbitration instead. And if you're going to resort to arbitration anyway, where you lose all the benefits of the secular legal system, so why should one not resort to halachic arbitration, which has the advantage of avoiding the risk of violating an isur d'oraita. But you can't ask people to do that until the system is set up in such a way that it has a reasonable capacity for justice. The only way to set that up is to make sure that zavla is regulated. The only way to make sure that zavla is regulated is to empower the local Beit Din to regulate the zavla. So that's the case I want to make tonight. That in an era where people don't like going to secular court and want ADR anyway, it's a good time to think about reviving the Beit Din system as a viable solution for Mammonot, both for the individual litigants and because it's a failure that we are creating a system which halacha has so little to say about what is so important to many of our lives, the way in which we run our financial affairs. But that there's a reason that doesn't happen right now, and the reason is not the populace that is to blame for not coming to court. It's because the system in fact broke, and you couldn't reasonably anticipate justice out of the system. But that there is, right, so when I said there is a way forward, right, you can take these two halachic positions and then everything else, right, and then an arbitration system is a reasonable way of achieving justice. And I hope that we can find a way to build it up, at least slowly, starting as a small claims court, or or any case where really what it's ideal for is a case where both parties just want to know what the right thing to do is. Right, that would be right. That's a great case to bring to Beit Din. And if we can have a couple of cases like that, which really work, then hopefully we can begin recreating Choshen Mishpat as a real part of Yahadut and have something to contribute to the world in that area as well. Thank you very much, as always, for the whole summer. Really appreciate letting me stand up here and talk, and hopefully it does some good for you also.